When police knock on your door for a domestic dispute, the first sentence you speak can send you to jail, even if you're the victim. As a lawyer, I'll show you exactly what officers are trained to do the moment they arrive, and how to protect yourself from becoming the one in handcuffs. The doorway decision. Your first 60 seconds. Determine everything. When police arrive at your home for a domestic dispute call, the first words out of your mouth can determine whether you walk away free or end up in handcuffs facing criminal charges. I'm going to show you exactly what law enforcement is trained to do the moment they step through that door, and more importantly, how to protect yourself from becoming the one they arrest, even when you're the victim. Domestic dispute calls are the most dangerous calls officers respond to. That's what they're taught in every academy across this country. Before they even knock, they're operating under the assumption that violence is occurring or about to occur. Their training tells them someone is getting hurt, someone is lying, and the situation can explode at any second. This mindset shapes every decision they make from the moment they arrive. Here's what civilians don't understand. Officers responding to domestic calls are not there to determine who's right or who's wrong. They're there to stop immediate violence, separate the parties, and in most jurisdictions, make an arrest. Mandatory arrest laws in over half of U.S. states require officers to arrest someone if they believe domestic violence occurred. Not might have occurred, not could have occurred, just if they believe it did. And belief is a remarkably low standard when officers are trained to look for specific indicators that confirm their pre-arrival assumptions. The moment they knock, your legal exposure begins. Most people answer the door emotionally, disheveled, sometimes injured, often angry or crying. Officers see this and immediately begin threat assessment. They're scanning your hands, your stance, your facial expression, the space behind you, and they're listening to background noise. If they hear yelling, breaking objects, or another person speaking loudly, their threat perception spikes instantly. Every officer is taught that domestic calls can turn lethal in seconds, so they enter hyper alert. This is why your first action when you hear the knock is not to fling the door open mid-sentence or mid-argument. You stop everything. You take 3 full breaths. You wipe your face if you're crying. You step away from the other person if they're nearby. Then you open the door calmly. When the door opens, the first officer is conducting what's called a threshold assessment. Within 3 seconds, they've decided how dangerous you are. If you're standing in the doorway blocking their view, hands moving, voice raised, or if someone behind you is yelling, the officer perceives threat. Their hand moves closer to their weapon. Their partner shifts position. Their body language hardens. You've just made yourself the problem. Instead, you open the door, step back 1 full step, put both hands at your sides where they can see them, and you say this exact sentence. Officers, I called for help. I'm the one who needs assistance. I'm calm and I want to cooperate. If you didn't call, you say, officers, I'm calm and I want to cooperate. Please tell me how I can help. This sentence does 3 things simultaneously. It establishes you as non-threatening. It frames you as the cooperative party, and it signals to their body cameras that you're stable and rational. Those first words set the tone for the entire encounter, and officers are trained to mirror the tone you give them. If you're stable, they stabilize. If you're chaotic, they escalate. Now let's talk about what happens in the next 60 seconds, because this is where most people destroy their own case without realizing it. Officers will ask you what happened. This seems like a straightforward question, but it's a legal trap. When you start explaining what happened, you're giving a statement. That statement can and will be used against you. Every word you say is being recorded on a body camera, written in notes, and will appear in police reports that prosecutors read. If you say anything that admits to physical contact, even defensive contact, you've just handed them probable cause for arrest. Here's how it works in practice. You're upset. You've been arguing with your partner for an hour. They pushed you pushed back. Police arrive. You're angry and you want justice. So when the officer asks what happened, you say, he pushed me first, so I pushed him back to get him away from me. You think you're explaining self-defense. The officer hears an admission of mutual combat. In many jurisdictions, mutual combat means both parties get arrested. Even in states without dual arrest policies, your admission of pushing gives the officer discretion to arrest you for domestic battery. You just incriminated yourself while trying to seek help. The correct response when officers ask, what happened, is not a story. It's a boundary. You say, officer, I want to make sure I do this correctly. I'd like to give a full statement, but I want to speak with an attorney first to make sure I don't say anything that's misunderstood. This is not suspicious. This is smart. Officers know this is smart. Prosecutors know this is smart. And it's your constitutional right under the 5th Amendment. You're not refusing to cooperate. You're protecting yourself from self-incrimination. The officer cannot legally use your invocation of rights as evidence of guilt. They cannot arrest you because you asked for a lawyer. And if they try to pressure you by saying, innocent people don't need lawyers, that's a psychological tactic. You repeat the the same line calmly. But here's the complication most people face. If you invoke your Fifth Amendment right, the officer may arrest you anyway based on visible evidence. This is why the next part is critical. Officers are trained to look for primary aggressor indicators. These are physical and circumstantial clues that tell them who was the main source of violence. Primary aggressor indicators include visible injuries, size and strength disparity, who has defensive wounds versus offensive wounds, who called the police, who appears more fearful, and who appears more aggressive or controlling during the interaction. If you're larger, male, and uninjured, and your partner is smaller, female, and has scratches or red marks, you're getting arrested even if you never touch them. Officers are trained to apply primary aggressor analysis specifically to avoid arresting victims. So if you're the one who didn't initiate violence but you're bigger or you're male, you need to make your case visually and verbally without giving a full statement. You say, "Officer, I did not initiate any physical contact. I defended myself. I have injuries you need to document. I want photographs taken of my injuries right now." Then you show them. If you have scratches, bruises, red marks, torn clothing, or anything else, you demand documentation. You say, "I need these photographed and included in your report." Officers are required to document visible injuries. If they refuse, you say, "Officer, I'm formally requesting that all my injuries be photographed and documented in the report. I'm not giving a full statement until I consult an attorney, but I need my injuries on record." This creates evidence without incriminating yourself. Let's talk about body language during this initial phase. Officers are trained to read your physical posture as much as your words. If you're pacing, they interpret agitation. If your fists are clenched, they see aggression. If you're gesturing wildly while talking, they perceive threat. Your hands need to stay visible and still. Your feet need to stay planted. Your shoulders need to stay relaxed. Your voice needs to stay level. You're not just managing the legal conversation, you're managing the visual record that will be reviewed later. When officers separate you and your partner, they're looking for consistency in stories, but they're also watching how each of you behaves when the other isn't present. If you immediately start bad-mouthing your partner, officers note that as vindictiveness. If you start crying and apologizing, they note that as guilt. If you ask repeatedly about your partner's well-being, they may interpret that as controlling behavior or fear that your partner will tell the truth. The safest position during separation is calm cooperation without volunteering information. You answer direct questions with minimal responses. "Yes, officer." "No, officer. I'd prefer to discuss this with my attorney present." You do not elaborate. You do not fill silence with explanations. Silence is not suspicion, it's protection. Here's another critical detail most people miss. Officers are required to write a report regardless of whether anyone is arrested. That report becomes a permanent record. Even if no charges are filed, that report exists in police databases. It can be subpoenaed in custody battles, referenced in future police encounters, and used in background checks for certain jobs. This means every interaction with officers during a domestic call is creating a permanent record of your behavior, your words, and the officer's observations. You must treat this encounter as if a jury is watching, because in many cases, a jury eventually will be. The primary aggressor trap. How officers decide who goes to jail. Now let's talk about the other person in the home. While you're talking to one officer, another officer is separating your partner and getting their version. This is standard procedure. Officers separate parties to prevent coordination of stories and to see if the stories match. Tells a completely different story than you. Officers assume someone is lying. In many cases, they assume the calmer person is lying because they've had time to compose a story, and the emotional person is telling the truth because emotion indicates honesty. This is flawed logic, but it's how many officers assess credibility in the moment. If your partner is hysterical, crying, and tells the officer you attacked them, and you're calm and controlled, the officer may believe your partner even if you're telling the truth. This is why your composure must be paired with evidence. If there's physical evidence that contradicts your partner's story, broken objects they broke, messages they sent threatening you, recordings of them yelling, you point this out immediately. You say, "Officer, there's evidence here that shows what actually happened. My phone has messages where they threatened me. There's a broken lamp they threw. I want all of this documented." You're not giving a statement about the sequence of events. You're directing officers to physical evidence that speaks for itself. Evidence doesn't require you to incriminate yourself. Evidence just exists. And officers are trained to collect evidence, so you're helping them do their job while protecting your legal position. Let's go deeper into how officers decide who to arrest. If both parties have injuries, officers apply a lethality assessment. They ask questions like, has the violence escalated over time? Has anyone been choked? Is there a weapon in the home? Has anyone threatened to kill the other person? Is anyone afraid for their life? These questions aren't casual. They're part of a standardized risk assessment tool used across the country to predict domestic homicide. If the answer to any of these questions is yes, the officer's perception of danger skyrockets, and they're far more likely to arrest the person they believe poses the lethal threat. If you're male and your partner says you choked them, even if you didn't, you're getting arrested. Strangulation is treated as one of the highest predictors of future domestic homicide, and officers are trained to take choking allegations extremely seriously. If your partner makes that allegation, you do not argue with the officer. You say, "Officer, that allegation is false. I did not choke anyone. I want to fully cooperate with the investigation, and I will provide a complete statement through my attorney. I'm requesting medical examination of both of us to document the absence of strangulation injuries." This does two things. It denies the allegation on camera, and it calls for objective medical evidence that can disprove the claim. Here's what most people don't understand about domestic violence law. The burden of proof for arrest is extremely low. Officers don't need to witness the violence. They don't need physical evidence. They don't need both parties to agree on what happened. All they need is probable cause to believe a domestic battery occurred. Probable cause can be established by one person's statement alone, especially if that person has visible injuries or appears emotionally distraught. This is why your partner's demeanor during the police interview matters as much as their words. If they're sobbing and shaking while telling officers you attacked them, and you're standing there calm and collected, officers will likely believe your partner regardless of the truth. This creates a strategic problem for people who are naturally calm under pressure or who have been falsely accused before and know how to stay composed. Your composure, which should be an asset, becomes a liability in the officer's assessment. The solution is not to fake emotion. That's transparent and counterproductive. The solution is to demonstrate your distress through factual statements rather than emotional display. You say, "Officer, I'm terrified right now because I'm being falsely accused. I've never been in this situation before. I need this handled correctly, which is why I want legal representation before I give a full statement." This communicates fear without hysteria, concern without chaos, and seriousness without aggression. Now let's address what happens when officers ask your partner if they want to press charges. In many states, this question is irrelevant because the state decides whether to prosecute, not the victim. But officers still ask because the victim's stated desire influences their decision about arrest. If your partner says, "No, I don't want charges, we just had a fight," officers may choose not to arrest if there are no serious injuries and no history of domestic calls at the address. But if your partner says, "Yes, I want him arrested," or even, "I don't know, I'm scared," officers will almost always arrest. This is why you cannot rely on your partner to protect you during a police encounter. Even if your partner loves you and doesn't want you arrested, their emotional state and their responses to police questions can put you in handcuffs. There's another dynamic at play that civilians rarely consider. Officers are evaluated on how they handle domestic calls. If they fail to arrest someone who later commits a serious domestic assault or homicide, their judgment gets scrutinized. This creates institutional pressure to arrest when in doubt. Officers would rather arrest someone who doesn't deserve it than fail to arrest someone who goes on to hurt or kill their partner. This means you're fighting not just the officer's assessment of the current situation, but also their fear of future liability. Understanding this helps you see why your behavior must be impeccable. You're overcoming a systemic bias toward arrest. Let's talk about children in the home. If children are present during a domestic dispute, the legal stakes multiply instantly. Many states have enhanced penalties for domestic violence committed in the presence of a child. Officers are also mandatory reporters for Child Protective Services. If they believe children witnessed violence or are in danger, they will contact CPS regardless of whether anyone is arrested. This can trigger a separate investigation that affects custody, living arrangements, and parental rights. If children are in the home when police arrive, you need to make sure officers understand the children are safe and were not exposed to violence. You say, "Officer, the children were not present during the argument. They were in their rooms with the doors closed. They are safe and unharmed." If the children were present, you do not lie, but you also do not volunteer information that makes the situation sound worse than it was. You let your attorney handle the detailed explanation later. Now we need to discuss the moment officers tell you you're under arrest. This is where most people make catastrophic mistakes. They argue, they resist, they try to explain, they get angry. All of this makes everything worse. When an officer says you're under arrest, the legal decision has been made. Arguing will not change it. The only thing arguing does is add charges. Resisting arrest is a separate crime. Obstruction is a separate crime. Battery on a law enforcement officer is a separate crime. Every time you pull away, tense up, or refuse to comply, you're adding criminal liability. So the moment you hear you're under arrest, your response is immediate and total compliance. You say, "Officer, I'm complying, I'm not resisting. I'm invoking my right to remain silent and my right to an attorney." Then you stop talking completely. You do not explain. You do not defend. You do not justify. You go silent. Here's why this matters so much. Everything you say after arrest is admissible in court. Officers will try to get you to talk in the patrol car, at the station, during booking. They'll say things like, "This will all go easier if you just tell me what happened." Your partner already told us everything. If you don't give your side, we only have their version. These are interrogation tactics. Officers are allowed to lie to you during interrogation. They can tell you your partner confessed when they didn't. They can tell you there's video evidence when there isn't. They can tell you cooperation will help you when it won't. Your silence protects you from all of this. Once you invoke your right to an attorney, officers must stop interrogating you under Miranda v. Arizona. If they keep questioning you after you've invoked, any statements you make can be suppressed in court. But you have to invoke clearly and unambiguously. You can't say, "Maybe I should talk to a lawyer." You can't say, "I think I want a lawyer." You say, "I'm invoking my right to an attorney and my right to remain silent." Then you stop talking. Let me give you the exact psychological framework officers use during the arrest decision. They're asking themselves 3 questions. Is there probable cause that a crime occurred? Who is the primary aggressor? What is the risk of future violence? Your behavior influences all 3 assessments. If you've stayed calm, asserted your rights without being confrontational, directed officers to exculpatory evidence, and documented your injuries, you've weakened the case for your arrest. If you've argued, raised your voice, admitted to any physical contact, or failed to document your injuries, you've strengthened the case against you. The arrest decision often comes down to which party appears more dangerous and more culpable in the moment, and you control how you appear after arrest. Let's shift to what happens after you've been arrested and you're sitting and holding. This is where the second wave of legal danger begins, because now you're going to be pressured to take a plea deal, sign a no-contact order, or make statements during your first appearance. Prosecutors in domestic violence cases operate under a prosecution without victim cooperation model in many jurisdictions. That means even if your partner doesn't want to press charges, the state will prosecute you anyway. They'll use your statements, officer observations, photographs, 911 calls, and medical records to build a case without your partner's testimony. This is why every word you said to officers matters. If you admitted to any physical contact, that's evidence. If you said you were defending yourself, that's evidence. If you said your partner started it, that's evidence. All of it gets used against you. When you finally speak to a public defender or private attorney, the first thing they'll ask is, "What did you tell the police?" If you gave a full statement, you've limited your attorney's ability to defend you. If you stayed silent, your attorney has maximum flexibility. They can negotiate from strength because the prosecution has to prove their case without your own words. This is why invoking your rights isn't about looking guilty. It's about preserving your legal options. Innocent people get convicted every day because they talked themselves into corners they didn't need to be in. Now let's talk about no-contact orders. After a domestic arrest, judges almost always issue a no-contact order as a condition of bail. This means you cannot contact your partner in any way. No calls, no texts, no social media, no third-party messages, no going near their home or workplace. Violating a no-contact order is a separate criminal charge, and it's one of the easiest charges to prove because it's usually documented electronically. If your partner contacts you first, do not respond. If they beg you to come home, do not go. If they say they'll tell the judge it was a mistake, do not believe it. The no-contact order isn't about what your partner wants. It's a court order that binds you. Violating it can get you rearrested immediately, your bail revoked, and additional charges filed. Even if your partner is the one initiating contact, you're the one who gets charged if you respond. The only way to modify or lift a no-contact order is through your attorney and a formal court hearing. Until that happens, you treat that order as absolute. Here's what makes no-contact orders particularly dangerous. They're often broad and vague. The order might say you can't contact your partner directly or indirectly. Indirectly can mean asking a friend to pass a message. It can mean liking their social media post. It can mean sending a gift through a delivery service. It can mean showing up at a location you know they'll be, even if it's a public place. Prosecutors interpret indirect contact expansively, and judges rarely give defendants the benefit of the doubt. If there's any ambiguity about whether your action violated the order, assume it did and don't do it. Let's discuss the first court appearance, which usually happens within 24 to 48 hours of arrest. This is where the judge sets bail conditions and you're formally advised of the charges. Most people show up to this hearing exhausted, scared, and desperate to get out of jail. That desperation makes them vulnerable to bad decisions. The prosecutor may offer a plea deal right away, something like pleading guilty to a lesser charge in exchange for time served and probation. This sounds appealing when you're sitting in jail wanting to go home, but it's almost always a mistake. A guilty plea, even to a reduced charge, is still a domestic violence conviction with all the consequences that follow. You lose your gun rights, you get a permanent criminal record, you may face immigration consequences, you damage your position in custody disputes. Never accept a plea deal at your first appearance without talking to your attorney and understanding every consequence. Here's another trap at the first appearance. Judges sometimes ask if you have anything to say. The correct answer is no, Your Honor. I'll be addressing this matter through my attorney. Do not try to explain what happened. Do not try to tell your side of the story. Do not say you were falsely accused. The courtroom is not the place for your defense. That comes later through proper legal channels. Anything you say in court is under oath and can be used against you. Prosecutors love when defendants talk at first appearances because desperate people say incriminating things without realizing it. Now, let's address what happens when your partner wants to drop the charges. This is one of the most misunderstood aspects of domestic violence prosecution. In most jurisdictions, the victim cannot drop charges. Once the state decides to prosecute, the case moves forward regardless of the victim's wishes. Your partner can tell the prosecutor they don't want to pursue charges, they can refuse to cooperate with the investigation, they can even testify on your behalf, but none of that guarantees the charges will be dismissed. Prosecutors have other evidence: your statements to police, officer observations, photographs, 911 recordings, medical records, and witness statements. They can proceed with all of that even if your partner refuses to participate. However, victim cooperation does matter. Cases are harder to prove without a cooperative victim, especially if the physical evidence is minimal. This is why prosecutors often pressure victims to cooperate through various means. They might subpoena your partner to testify, threaten them with contempt charges if they refuse, or suggest that their refusal to cooperate makes them complicit in future violence. Your partner needs to understand they have rights too, including the right to consult with an attorney before deciding whether to cooperate with prosecution. If your partner genuinely wants the charges dropped, they should hire their own attorney to navigate this process, not just rely on what the prosecutor tells them. Let's talk about pretrial diversion programs and deferred prosecution agreements. Many jurisdictions offer first-time domestic violence offenders the option to complete a diversion program instead of going to trial. These programs typically require you to plead guilty or no contest, complete anger management or batterer intervention classes, stay out of trouble for a specified period, and comply with all court orders. If you successfully complete the program, the charges are dismissed and you avoid a conviction. This sounds like a great deal, and for some people it is, but you need to understand what you're agreeing to. You're still admitting guilt, even if it doesn't result in a conviction. That admission can be used against you in civil proceedings like custody cases. You're also committing to months or years of program participation, which costs money and time. And if you fail to complete the program or get arrested again during the diversion period, you'll be convicted of the original charge with no trial. Before accepting diversion, your attorney needs to evaluate whether the evidence against you is strong enough to convict you at trial. If the case is weak, fighting it might be smarter than accepting diversion. Here's the reality about domestic violence trials. They're difficult for both sides. Prosecutors struggle when the victim won't cooperate, and physical evidence is minimal. Defense attorneys struggle because juries are often sympathetic to alleged victims and skeptical of defendants, especially male defendants. This creates space for negotiation. Experienced defense attorneys can often negotiate reduced charges, deferred prosecution, or even dismissal if the evidence is weak or the victim is uncooperative. But these negotiations require leverage, and leverage comes from a strong factual record. This brings us back to everything you did during the initial police encounter. If you stayed calm, invoked your rights, documented your injuries, directed police to exculpatory evidence, and didn't make incriminating statements, your attorney has leverage. If you argued with police, admitted to physical contact, failed to document your injuries, and made emotional statements, your attorney has nothing to work with. Let me address a question many people have. Should you take the case to trial? The decision to go to trial depends on multiple factors. How strong is the prosecution's evidence? Is your partner cooperating with the state? Do you have credible witnesses or physical evidence supporting your version? What are the potential penalties if you're convicted? What is the prosecutor offering in plea negotiations? How much will trial cost in attorney fees? What are the collateral consequences of a conviction versus a plea to a reduced charge? These are complex questions that require careful analysis with your attorney. What I can tell you is this: never let fear alone drive your decision. Some people plead guilty to crimes they didn't commit because they're terrified of going to trial and losing. That fear is understandable, but it shouldn't be the only factor. If you're innocent and the evidence is weak, fighting may be the right choice even though it's scary. Here's the final piece most people never consider: the long-term consequences of a domestic violence conviction. A domestic violence conviction isn't just a criminal record. It's a federal prohibition on firearm ownership under the Lautenberg Amendment. If you're convicted of even a misdemeanor domestic violence offense, you lose your Second Amendment rights for life. You cannot own a gun. You cannot possess a gun. You cannot live in a home where there's a gun. If your career involves firearms, law enforcement, military, private security, a domestic violence conviction ends your career. If you're not a U.S. citizen, a domestic violence conviction can make you deportable. If you're in a custody battle, a domestic violence conviction can cost you your children. These consequences are why domestic violence charges must be taken seriously from the first moment police arrive, because what you say and do in that initial encounter shapes everything that follows. That brings us to the end of this story. For more interesting videos like this, click on the cards on your screen.